How's everybody doing? Great, really great to be learning with you on a Wednesday night, Yom Revi'i, a Wednesday afternoon, Yom Revi'i. I mean, we had those technical problems yesterday, and I was troubleshooting after the show for hours. It's always something. There's just so many little things that can go wrong. That finding out which one it was and where was the interface between, Facebook and the streaming software, whatever, no one cares. But thank God we're up and running. Thank you so much, God. Okay. Yehudit in South Carolina, Stephen in New Hampshire, Guy in Ohio, Paul in the Great Northwest, Sharon in New Jersey, Bella in Florida, Melissa in Great Neck, John in Maine, Joe in the Inland Empire, Bill in Missouri, Karen in Northern California, Yitzhak in Minnesota, Nancy, North Carolina, Randy in Florida, Spencer in Connecticut, Paula, knew you'd get it. Thank you for the Muna Bitachon, the faith and trust. Frank, is this volume on? Okay. Franco in Trieste, welcome. Marie in New York. Let's light up the darkness. Okay. I had to uninstall all the software and reinstall it. That's what finally did it. And then I had to recreate the settings. So let me know if anything is not quite right. Particularly, is the audio good? Is it the same as always? Let me know. Okay. Let's get this up. Here we go. Okay, our daf today is page 96 here in Tractate Bava Metzia, the 22nd volume of the Talmud. We're picking it up toward the bottom of page 95b. It is a longish page, so let's be efficient and get to it. Thank you, Yehudit. Everything is good. Thanks to here, and thank you, Lucy. Okay. The Gemara, so we were deriving yes, it was a very complex page of all days for things to break down. Very difficult page. But basically, we were seeing that the borrower, the renter, the paid bailee, the unpaid bailee, each have different levels of liability, and then each have different cases. How did the loss happen? Are they going to be responsible? Are they not? Then we brought in the exception, right? That if the borrower is always liable, and today we're going to see, well, no, the borrower is not always liable. The borrower is liable if there's theft, if there's loss, and if there's injury or death, but injury or death due to circumstances beyond his control. And today we're going to test that. But then we saw that he's liable in all these cases, but he's not liable if the owner of the thing that he's borrowing comes along with the item, like, for example, an ox that he's going to borrow to plow his field. If the owner of the ox comes at the time that the borrower borrows the ox, and the owner of the ox comes to lend his services, to be employed, almost to just be on the property, but he comes at the time that the borrower borrows, then if these things happen, the borrower will be exempt from liability. We tested, what if the borrower, the owner came with the item, but the borrower was also negligent? Then what? We didn't really resolve that question. And that was yesterday's discussion. So we pick it up. The Gemara explains how the first of these baraisas that we were studying at the end of yesterday came to its conclusion. So Abaye holds, in accordance with the opinion of Rabbi Yoshia, that when the Torah mentions two details together in reference to a law, it is presumed, because we were testing, does the negligence of the borrower change his exemption from liability if the owner came along with the ox? And we were learning out, the only one of these custodians that mentions negligence is the unpaid bailee, who has the lowest degree of responsibility, but he is responsible if he's negligent. So are we going to extend that principle all the way up to the borrower, who's sort of two steps away, since the borrower is compared to the renter and the unpaid bailee and the paid bailee, which are in the middle? Are we also going to compare him to the unpaid bailee, which is two steps away? Right, so Abaye holds, in accordance with the opinion of Rabbi Yoshia, now when the Torah mentions two details together in reference to a law, it is presumed that the law applies only when both details are in effect. And he likewise explains the two verses in accordance with Rabbi Yoshia. And Rava holds, in accordance with the opinion of Rabbi Yonasan, that it is presumed that the law applies even when only one of the details is in effect. And he explains the verses in accordance with the opinion of Rabbi Yonasan. So let's explain why we're mentioning this. So when the Torah refers to an owner working for the borrower, and he's not just present, the way I said before. He's working for the borrower so that they have formed an actual relationship, not just an incidental, casual relationship. It's somehow more official than that. So when the Torah refers to an owner working for the borrower, it should be understood as referring to the time of the borrowing and the time of the mishap. Right? That's what we said, that the borrower has to come along with the animal. If the borrower borrows the animal and uses it for whatever, and then a little bit later he borrows the services or hires the services of the animal's owner, then he's going to be liable in all cases because the owner of the animal didn't come along with the animal. He has to have, the owner needed to come along with the animal at the time of borrowing. So now what we're asking, but does the owner have to be present at the time of the mishap in order for this exemption from the borrower's liability to work? Wouldn't it make more sense that, he's exempt from liability because the owner of the animal was there, but if the owner of the animal wasn't there, why would he be exempt from liability? Answer, because when the animal entered his domain, the owner was with the animal. That's the dispositive time, but we're testing that, right? So according to Rabbi Yoshia's opinion, this indicates that the owner worked for him at both times. Whereas, according to Rabbi Yonasan's opinion, this implies that he worked for him at either time, right? When the borrowing was done and when the mishap occurred to the animal. Based on this, Abaye and Rav explain the verses. Abaye holds in accordance with the opinion of Rabbi Yoshia, and he likewise explains the two verses in accordance with the opinion of Rabbi Yoshia, thereby arriving at the conclusion of the Baraisa like this. From the verse, if its owner is not with him, he shall pay. Right? The opposite was, if the owner of the animal is with him, he shall not pay. The borrower is not liable because the owner of the animal is there. But if the owner is not with him, he shall pay. So it appears that the reason the borrower is liable, meaning he shall pay for the mishap of the animal, is that the owner was not working for him at either point in time. By inference, if he worked for him at one of those times but not at the other one, the borrower is exempt. Not where the law ended up. It has to be that he was with at the time of borrowing, whether or not he was there at the time of the mishap. But in this rendition of the law, maybe it was enough to trigger the exemption if the owner was there either at the time of borrowing or at the time of the mishap. Now, the Gemara objects. But isn't it written, if its owner is with him, he does not pay? And from this verse, it appears that the reason the borrower is exempt is that the owner was working for him at both points in time. And by inference, if he was working for him at one of those times but not at the other, the borrower is liable. So the two verses appear to contradict each other. And to reconcile the verses, one must say that the phrase, if its owner is with him, serves to tell you, if he was with him, i.e. working for him, at the time of borrowing, he does not need to be with him at the time when the animal is injured or dies for the exemption of liability to apply. That's the law. But if he was with him at the time when the animal is injured or dies, he does need to have been with him at the time of borrowing for the exemption to apply. And that is the law. Now we're on 96a. By contrast, Rava holds in accordance with the opinion of Rabbi Yonasan, and he explains the verses in accordance with the opinion of Rabbi Yonasan, thereby arriving at the conclusion of the Baraisa, as it is taught in a Baraisa, if its owner is with him, he does not pay, teaches about the case in which the owner was working for the borrower at both points in time. And it also teaches about the case in which he was working for him at one of those times, but not the other one. In both cases, the borrower is exempt. So, of course, the Gemara objects. But it is also written, if its owner is not with him, he shall pay. And the verse teaches about the case in which the owner is not working for the borrower at either point in time. And it also teaches about the case in which he was working for him at one of those times, but not at the other one. In both cases, the borrower is liable. And to reconcile the verses, one must say that the phrase, if its owner is with him, serves to tell you that if the owner was with the borrower, i.e. working for him, at the time of borrowing, then he does not need to be with him at the time that the animal is injured or dies for the exemption of the liability to apply. But if he was with him at the time when the animal is injured or dies, he does need to have been with him at the time of borrowing for the exemption to apply. We arrive at the same result, which is the law. But the Gemara raises a difficulty. I could reverse the conclusion and say that the borrower's exemption from liability is dependent upon the time when the animal was injured or died. And the Gemara explains it is reasonable that the exemption from liability should be dependent on the time of borrowing because the borrowing is of greater significance as with it, the borrower brings the animal into his domain. Okay, so now, a moment ago, we were testing how we can, using interpretation and our principles of interpretation extending from one detail of one law to a related law that lacks that detail. Okay, so very, very much Talmudic interpretation. Now we're testing logic, right? Just kind of our basic common sense logic. So if you were going to say that you don't need the owner of the animal to come along with the animal both at the time when the animal was borrowed and at the time that the animal was injured, and that it's enough for the owner to have been there at one of those, so which one would make more sense in order to exempt the borrower from liability for this injury or death or theft or loss of the animal? I mean, I think our first impulse would be to say, well, the owner of the animal was present when the animal was injured. If he was present when the animal was injured, he was supervising the animal, it happened under his watch, why should the borrower have to pay? What difference does it make that the owner came along with the animal at the time that the borrower borrowed the animal? If the owner then left and the borrower was left with the animal for who knows how long, and who knows what he did and how the animal was treated, and then something happened to the animal, you would think that the time of the mishap is more important and more dispositive. And we've already heard that it's not. So let's see if we can wrap our heads around why the time of the borrowing is more important than the time of the mishap. So that's what's being asked here, right? Where am I? Okay, so it is reasonable, says the Gemara, that the exemption from liability should be dependent on the time of the borrowing, because the borrowing is of greater significance. Why? Because it's at the time of the borrowing that the borrower brings the animal into his domain. It's when everything gets set up. So the Gemara retorts, on the contrary, the time when the animal is injured or dies is of greater significance, because that point marks when the borrower actually becomes liable to pay for an accident that occurred? The Gemara answers, no, the borrowing is more significant. Were it not for the initial borrowing, what liability could be caused by the fact that the animal had an accident and was injured or died? And so the Gemara retorts, right? The Gemara takes both sides of the argument, as what we should all learn to do. But by the same logic, were it not for the fact that the animal is injured or dies, what liability would have been caused by the fact that the animal was borrowed? And the Gemara concludes, even so, the borrowing is of greater significance, as with it, the borrower is obligated to provide the animal's sustenance as long as it is entrusted with him. That is when the borrower's responsibility begins. And if at the time that his responsibility begins is when the animal's owner came along with the animal, then we can expect that the owner trained the borrower how to use the animal, looked around and saw what conditions the animal would be used under, discussed with the borrower how the animal would be fed, how it would be sheltered, etc. And everything was done to the satisfaction of the owner. Of course, that is the more important time, because as is the beginning, so is the continuation, right? I mean, obviously, if you take this as a spiritual lesson, you say, oh, wait a minute, there's many things in my life that I began badly and then later got it together and did right. Yeah, but think how many times, you had an instinct that something was a little off and you proceeded anyway, and that thing you had an instinct about was the bad seed that eventually germinated into a big problem, right? The roots of all big problems, might have been seen at the beginning. So much easier to stop the problem before it starts than to try and ameliorate it when it's a full-blown calamity, right? So the beginning is more important. Rav Ashi said that the law, that the borrower's exemption from liability is dependent upon the time of borrowing, as opposed to the time of the mishap, can be derived from the verse itself. The verse states, and when a man borrows from another, ... he shall pay. So the precise formulation of the verse indicates that he borrowed an item from another, but that other person was not with him, i.e. working for him at the time. It is only in such a case that the verse concludes, he shall pay, the borrower shall pay for the mishap. By inference, when the other person is working with him, the borrower is exempt. Accordingly, it is clear that the critical moment is the time of the borrowing. The Gemara asks, if so, why do I need the continuation of that verse? Its owner is not with him. And the next verse, if its owner is with him. So according to Rav Ashi, the circumstances of the borrower's liability and exemption can be derived from the beginning of the first verse. So why do we need more information? And the Gemara explains, if it were not for these additional clauses, I would say that this phrase, from another, is simply the usual manner of the verse and not to be expounded to teach an exemption. Since the continuation of the verse and the next verse teach the actual exemption from liability, and the apparent contradiction between them raises the question of when the critical moment is, it becomes apparent that the beginning of the verse was written in the manner that it was written in order to be expounded as Rav Ashi did, meaning that's how we learn out that the dispositive moment is, did the owner of the animal come along with the animal at the time that the animal was borrowed? Rami Bar Chama raises a dilemma. If one borrowed an animal in order... here we go. If one borrowed an animal in order to engage in bestiality with it, God forbid, a severe transgression, right? That's a death penalty offense. Then what is the law? Is the borrower liable for mishaps? So he borrows it for bestiality, and in the course of doing that, the animal is injured. Okay, then what? So the crux of the dilemma is, in order for him to be liable, do we require that the borrowing be for a purpose similar to that for which people typically borrow animals? And since people do not typically borrow animals for this purpose, the borrower is exempt. Or perhaps, what is the reason that a borrower is liable? it is due to the benefit he derives from the animal. And this borrower too, according to his warped, desires, derive benefit from the animal. Right. So in other words, if the borrower borrowed in order to get benefit and he got benefit and then something happened to the animal, he should be liable. But since in this case it was a bizarre occurrence, so out of the ordinary, where the animal was borrowed for some ulterior sinful purpose. Now the Gemara doesn't go into this part of it, but if this guy, is convicted of bestiality, he's subject to the death penalty. So actually, he might not have to pay for the animal because he's got to, deal with being executed. But that's actually not what the discussion is here. Really, they're using this extreme case to test the question of how important is it the purpose for which the animal was borrowed in terms of does that have an effect on the level of liability that the borrower has? And now we don't even answer that question. We go on to a series of related questions. Similar question. If one borrowed an item, not to use it, but rather to be seen with it, so that people will assume that he is wealthy, then what is the law? In order for him to be liable, do we require that he borrow an item of monetary worth? And that does exist in this case. The animal is worth money. Or perhaps we require for him to be liable that he borrow an item of monetary worth from which he also derives tangible benefit. And that does not exist in this case. Very interesting. You could quickly argue, well, status, people have status symbols. Maybe having a status symbol helps them close a deal. That's why they borrowed the animal. We talked, weeks or months ago about somebody who borrowed money, not to borrow the money and spend it, but rather just to have like a big, what do you call it? Like a wad of money, like he should look like somebody who's carrying around a lot of cash, because that will impress others, and he will get some kind of benefit from that. But we said actually that no, in that case you could rent the money in order to use it, and you wouldn't have an interest problem, right? Because you don't actually use that money, you only show it. Well, what about this? If you borrow an animal just to show that you have it, but you don't do work with it, you don't do anything with it, it's just that it's seen in your possession. Do we say that that kind of benefit is equivalent to the kind of tangible benefit for which you would normally borrow an animal, and therefore if anything happens to it while it's in your care, it's the same result as if you were plowing with it? We don't get an answer. Rather, another question. If one borrowed an item to perform work with it that is worth less than the value of one peruta, less than the smallest coin, less than a penny, what is the law? Do we require only that he borrow an item that has monetary value, and that exists in this case, or perhaps any benefit derived that is worth less than one peruta is seen as nothing, i.e. it is legally considered to be of no monetary worth, and he is therefore exempt because he didn't do anything with the animal when he borrowed it? Another question. If one borrowed 2 cows to perform work with them that will be worth the value of one peruta in total, then what is the law? When appraising the value of the benefit derived to see if it has monetary worth of one peruta, do we say follow the borrower and the lender, i.e. appraise how much benefit the borrower received from the lender, and in this case, there is the value of at least one peruta, or perhaps we follow each cow, and in this case, each of the cows did not provide 1 penny worth of work because together the 2 cows provided only a penny's worth of benefit. No answer. Next question. Where we're going with this is that all these questions don't get answered. And why that matters is because they didn't get answered, the law is left in an uncertain state. Therefore, if somebody were to make a claim according to one of these examples of open questions, the court would not step in and remove the damages from the defendant because the law is not clear enough, the law was never resolved in order to extract money from the defendant in favor of the plaintiff. On the other hand, at least in some of these instances, when you have such a case of doubt and unclear law, if the plaintiff on his own seized payment to pay off this kind of a liability, the court won't step in and reverse it. Right? So that's what it means when you have a law that was left unresolved. So similar question. If one borrowed an item from two partners and the services of one of those partners were also borrowed by him, then what is the law? Does the exemption of borrowing an item together with its owner apply in this case? For the exemption to apply, do we require that all of the owners of an item be working for the borrower, and that does not exist in this case? Or perhaps there is no such condition, but in any event, the borrower should at least be exempt from liability for that half of the item owned by the partner who did come and work for him? Not answered. Another question. In the case of partners who borrowed an item and its owner's services were also borrowed by one of them, well, then what is the law? The reverse case. Not two partners own the cow, but two partners borrow the cow. For the exemption to apply, do we require that the owner be working for all of the borrowers, and that does not exist? Or perhaps there is no such condition, but in any event, the partner who borrowed only the item should at least be exempt from liability for the half of the animal that the partner whom the owner worked for had borrowed. Another question. If one borrowed an item from a woman and the services of her husband were also borrowed by him, or where a woman borrowed an item and its owner's services were also borrowed by her husband, then what is the law? We're basically asking, does a husband and wife form a unit so that if you work with one of them, you've worked with both of them or not? Right? A husband has the right to use his wife's property. So these questions are dependent on whether ownership of the right to use an item and the profits that it engenders is tantamount to ownership of the item itself or not. Right? So for example, we saw that a wife who brings property into a marriage, if the marriage ends, like they divorce, she takes that property back with her. But while they're married, the husband has the right to use that property and to keep the produce that he produces from that field. Let's say she brings a field, he farms that field, it produces grain or fruit or whatever, and he benefits from that. He can keep that, and that's called usufruct property that she brought into the marriage. So do we say that because he has the right to use the property that technically his wife owns, is he considered like the owner of that field? Or because she brought animals into the marriage, so he can use those animals while they are married, and he gets the right to use that because he also has the obligation to sustain his wife. Right? He has to feed her, clothe her, shelter her, etc. That's why he has the right to use property that she brings into the marriage. Now that he has that right to use that property, if somebody borrows the animal, if the animal belongs to her, right? But the husband goes and works with the animal, is he considered to be like the owner of the animal, such that the borrower's exemption from liability would apply or not? Right? So if one borrowed an item from a woman and the services of her husband were also borrowed by him, right? That's the case I just said. Or where a woman borrowed an item and its owner's services were also borrowed by her husband, then what is the law? And it depends on this question that I just said. So Ravina said to Rav Ashi, in the case of one who says to his agent, now we're going to say, is a husband like the agent of the wife? That's why we're bringing in this principle in agent law. Ravina said to Rav Ashi, in the case of one who says to his agent, go and lend your services to somebody on my behalf, together with lending my cow to that person, what is the law? So for the exemption to apply, do I require that the cow's actual owner work for the borrower? And in this case, that does not exist. Or perhaps, since the legal status of a person's agent is like that of himself, it is sufficient if his agent works for the borrower, and accordingly, the necessary conditions for the exemption to kick in have been met. So Rav Acha, the son of Rav Avia, said to Rav Ashi, this question concerning a husband is subject to a dispute between Rabbi Yochanan and Reish Lakish, and the question concerning an agent is subject to a dispute between Rabbi Yonasan and Rabbi Yoshia. And the Gemara explains, the question concerning a husband is subject to a dispute between Rabbi Yochanan and Reish Lakish, pertaining to the requirement to bring the first fruits of one's field to the temple and recite the accompanying declaration. So before we say what's going on here, what is that declaration? What is that law? Little background. The first fruits of the new harvest were given to the priests. So during the temple period, a farmer would select the first fruits of the 7 types of produce with which Eretz Yisrael, the land of Israel, is specially favored. Those are the 7 species, right? Wheat, barley, grapes, figs, pomegranates, olives, and dates. And these are listed in Deuteronomy 8:8. So the sages instituted an ordinance that at least 1/60th of the harvest is brought as first fruits. How would this work? The farmers would bring these fruits to the temple in a basket and place them before the altar, which made a beautiful display around the altar, decorated by all this freshly harvested fruit that people brought and made the festival so beautiful. And when they brought the bikurim, the first fruits, the person who brings it would recite a declaration expressing appreciation to God. And then afterward, the first fruits were given to the priests who partook of them under the same conditions in which they partook of teruma. They had to be tahor, ritually pure, and the fruit had to be ritually pure. And the first fruits were brought to the temple between the festivals of Shavuos and Sukkot. Right, so Shavuos is next week. And from then until the fall holiday of Sukkot, so all summer and fall, right, is the harvest. And if they were not brought within this period, they could still be brought until Hanukkah. And Tractate Bikurim in the Mishna and the Jerusalem Talmud are devoted to the laws and provisions governing this mitzvah. Why are we bringing it up? Because after the fruit is deposited in Jerusalem at the altar, as part of giving it to the priest, the one who brings it has to make a declaration that he brought the fruit that he was obligated to bring. Why was he obligated? Because he owns the field where it was brought from, where it was harvested from. Why does that matter? Well, what about a husband who has the usufruct benefit of his wife's property? Does he own it or does he not own it? Very interesting. Not community property. It's not that if one owns it, the other owns it because they're a community. No, she owns it and he gets to use it. Is that the same as owning it? That's the question. Rabbi Yochanan says that the buyer brings the first fruits, right? Because because part of that declaration that he makes is the land which you, the Lord, have given me. Right? So whenever the owner of one of these fields in Israel would bring the fruits, he acknowledges that the only reason he owns that field is because God gave it to him. He might have saved up a lot of money and bought it, but the reason why any Jews had the land in the first place in the ancient kingdom is because God led the children of Israel out of Egypt through the wilderness and into Canaan and made it the land of Israel through the wars of conquest, but it was a gift from God. And you acknowledge and remember that gift for generations and generations afterward when they would bring these fruits. So, that declaration says, the land which you, the Lord, have given to me. Rabbi Yochanan says that the buyer brings the first fruits and recites the declaration because he holds that ownership of the right to use the land and its produce is tantamount to ownership of the land itself. I'm sorry, I skipped something. Yeah, so the reason, we're not talking about husband and wife here yet. We're talking about a buyer, right? And so the reason is because somebody didn't buy the field, right? And they never really could buy fields. You were buying crop years, right? You were buying the right to farm that field for a certain number of years until the Jubilee year would come, and then that field would revert, right, to its ancestral holding. So that's why the buyer didn't buy the land. He bought the right to farm the land for a certain number of years. And that's why they're saying somebody who bought the right to farm land for a certain number of years, does he bring the first fruits and does he make the declaration? So Rabbi Yochanan says that the buyer brings the first fruits and recites the declaration because he holds that ownership of the right to use land and its produce is tantamount to ownership of the land itself. Accordingly, the buyer is considered to be the owner of the land and he may consequently recite the declaration. And Reish Lakish says that the buyer brings the first fruits but does not recite the declaration because he holds that ownership of the right to use the land and its produce is not tantamount to ownership of the land itself. Accordingly, the buyer is not considered to be the owner of the land and is consequently unable to recite that declaration where he would say, the land you have given me. And that is the law. This is one of those cases where Reish Lakish, right, who was the student of Rabbi Yochanan, eventually colleague, sort of wins the argument, right? The law is according to Reish Lakish that somebody in that situation brings the fruits but doesn't recite the declaration. Now, the Gemara clarifies the second disagreement where it is about a husband and wife. The question concerning an agent, it'll get to a husband and wife. First, we're going to talk about an agent. So the question concerning an agent is subject to a dispute between Rabbi Yonasan and Rabbi Yoshia. As it is taught in a Baraisa, if there is one who says to a steward appointed to take care of his household, all vows that my wife will vow from now until I come from such and such a place, you should nullify them for her in my stead, and the steward annul them for her, so one might have thought that they would be nullified. To dispel this notion, the verse states with regard to a vow taken by a wife, her husband sustains it and her husband nullifies it, which indicates that only her husband is able to do so and no one else. This is the statement of Rabbi Yoshia. That is the law. Right? So a husband can nullify his wife's vows for her. That's a leniency for her. This is not actually the patriarchal system taking advantage of her. This is a benefit to her. Because if the husband vows a vow, and he would like to have it nullified, as would so often be the case, he has to find a sage, a paskening rabbi who can nullify it for him, or he might have to convene a court of sages to nullify it for him. Very difficult. The wife has the leniency that she can go to her husband and he can nullify it for her. But only her husband can do that. He cannot appoint an agent to do that for him. Rabbi Yonasan says, we have found everywhere in halacha that the legal status of a person's agent is like that of himself. Since the steward was the agent of the husband, his nullification of the vows is effective. Sounds good, but Rabbi Yonasan was wrong about that one. Another question. Rav Ilish said to Rava, in the case of one who says to his Canaanite slave, go and lend your services to another together with lending my cow to that person, then what is the law? Let the dilemma be raised according to the one who says that the legal status of a person's agent is like that of himself, but let the dilemma also be raised according to the one who says that the legal status of a person's agent is not like that of himself. We've already seen that in the case of where a husband cannot appoint an agent to nullify his wife's vows. So there are times when a person's agent cannot do what a person himself can do. But in many other cases, the person's agent is considered to be just like himself. So we're going to evaluate it both ways. So the Gemara explains, let the dilemma first be raised according to the one who says that the legal status of a person's agent is like that of himself. Like this. Does this matter apply only to an agent who is obligated in mitzvahs, just like the one who appointed him? But for a slave who is not fully obligated in mitzvahs, the principle does not apply. Right? Remember, if I lend my neighbor my cow, and then I go with the cow, and then while it's plowing my neighbor's field, and I'm present, working for my neighbor, lending my services, and something happens to the cow, then even though my neighbor didn't pay me for the cow, he's a borrower, he's going to be exempt from liability because I went with the cow. That we've established. If I send my agent with me to represent me, so then does the exemption from liability apply or not? And then if I send my slave, terrible, when slavery existed, is it a different outcome? And why would it be different? Because my agent, who's my fellow Jew, is obligated in mitzvahs and is an independent person. My slave, my Canaanite slave, doesn't have control of his time. So the slave ends up being considered like an extension of my hand, whereas an agent, who is somebody that I appoint for a specific task, but who is an independent person who's obligated in mitzvahs, might not have the same relationship to the cow and the borrower that I would have or that my slave would have, right? That's the issue at hand. Right, so does this matter apply only to an agent who is obligated in mitzvahs, just like the one who appointed him, but for a slave who is not fully obligated in mitzvahs, the principle does not apply, or perhaps even according to the one who says that the legal status of a person's agent is not like himself, maybe that applies only to an agent who is a free independent person, but in the case of a slave, since he has no independence from his master, as the possession of a slave is like the possession of his master, i.e. anything that the slave acquires is automatically acquired by his master, so perhaps if the slave's services are borrowed, it is the same as if the master himself had been borrowed. And Rava said to Rav Ilish, it stands to reason that the possession of a slave is like the possession of his master, then one who borrows both another's item and the services of his slave is exempt from liability. And that's the law. So if I lend my neighbor my cow and I go along with the cow, something happens, my neighbor's exempt. If I send my slave along with the cow and something happens to the cow while the slave is there who went along with the cow from the outset, the borrower is exempt. If I send my agent along with the cow, even from the beginning, and he is there and the agent is there with the cow while it's being used by my neighbor who borrowed it, and something happens, the exemption from liability does not get triggered and the borrower must pay because the agent is not the same as the owner. Rami Bar Chama raises a dilemma. What level of liability does a husband bear with regard to his wife's usufruct property? Back to that question that we digressed from. This is property belonging to the wife that the husband has the right to use and enjoy its profits while they are married, but that is returned to her upon the termination of the marriage. And now we're on page 96b. Is he, the husband who has a right to the wife's usufruct property, is he like a borrower or is he like a renter of that property? Rava said to Rami Bar Chama, commensurate to the sharpness of his mind is the extent of his error. Whichever way you look at it. In other words, you're very sharp, but you made a big mistake here. As sharp as you are is how big a mistake you made. Because you're so sharp that you didn't get this is a very big mistake. So it's a very backhanded compliment there. Because whichever way you look at it, the husband is exempt. If he is like a borrower, well, this is a case of borrowing an item together with the services of the owner, as his wife is obligated to perform household services for him. She's his wife. He has to feed her, and she has to run the household. Alternatively, if he is like a renter, this is a case of renting an item together with the services of the owner for the same reason. Either way, he should be exempt. But the Gemara reinterprets Rami Bar Chama's question. He wasn't saying, is the husband a renter or a borrower with respect to this usufruct property? Rami Bar Chama understands that the wife lives with the husband, and therefore she comes along with whatever the husband is borrowing or renting from her. That's not what he meant. Rather, when Rami Bar Chama raised the dilemma, it was with regard to a case in which a man first rented a cow from a woman and subsequently married her. So in that case, she was not working for him at the time that he began renting the cow. And so the exemption of borrowing an item together with its owner does not apply. So Rami Bar Chama's question was, what is the law once they do get married? This is dependent on whether from that point he is like a borrower or he is like a renter. And the Gemara explains, since the husband initially rented the cow, if he is now like a borrower, then his status has changed. And so the new borrowing of the cow done together with borrowing the services of its owner, right, meaning his wife who became his wife, since he went from renter to borrower when they got married, and she was present when they got married, so now it's like the owner is along with the animal and he's exempt from having to pay her if it's damaged. But if his status didn't change, if he is still considered a renter, well, then the property that he was renting at the time that he rented it did not come with the services of its owner, and so he would be liable, even though she is present now. Right? So it's a very interesting question. Rabbi Bar Chama, clever guy. Or perhaps even once he is married, he is still like a renter. And since his status has not changed, the renting stands as it was, i.e. his current renting of the cow is considered a continuation of the initial renting that began before his wife was obligated to work for him. And consequently, the exemption would not apply. The exemption would not apply, right? Because when he first rented the animal, the owner didn't come with it. So now if something happens to the animal, he's not exempt, he has to pay. So the Gemara challenges this logic. But what is different about these possibilities that you say? That only if he's a borrower is it so that the new borrowing of the cow done together with borrowing the services of the owner comes and displaces the initial renting that was done without borrowing the services of the owner. Say the same also if he is now like a renter, and let the new renting of the cow done together with borrowing the services of the owner come and displace the initial renting that was done without borrowing the services of the owner. In other words, he was initially renting from a woman. When she became his wife, he gave it back. And then if he's considered to be still using it under that same rental agreement, it's like a new rental agreement, and this time the owner came with the animal. Right, so the Gemara reinterprets his question. Rather, when Rami Bar Chama raised the dilemma, it was with regard to a case where a woman rented a cow from someone in the world at large, and subsequently another man married her. So the Gemara explains the relevance of this dilemma is dependent on a dispute between the rabbis and Rabbi Yosef concerning a case in which one rents a cow and then another person borrows it from the renter. Not like a sublet, but a sub-borrow from an initial case of renting. So who does the borrower owe his liability to? The person he borrowed from, which is, the person he borrowed from, but that person was renting from the original owner. So who does he owe to? And we discussed that on page 35a. So according to the opinion of the rabbis who say that the borrower pays the renter, do not raise the dilemma, as it is certainly a case of borrowing an item and borrowing or hiring its owner with it. Evidently, the rabbis hold that for the duration of the rental period, the renter is considered to be the owner of the cow. Accordingly, in this case, the woman is considered to be the owner of the cow. Therefore, when the man marries her, he is considered to be borrowing the cow from her at the same time at which she becomes obligated to work for him. So when should you raise the dilemma? Raise it according to the opinion of Rabbi Yosef, who says that the value of the cow must be returned to its original owner, not to the middleman. Rabbi Yosef holds that the renter is not considered to be the owner of the cow. And therefore, when one borrows from somebody who rented originally, and then something happens to the animal, the person that he owes money to is the actual owner. Right? Rabbi Yosef holds that the renter is not considered to be the owner of the cow, and therefore this is not a case of borrowing an item together with borrowing or renting the services of its owner. Therefore, Rami Bar Chama asks what level of liability the husband bears. Is he like a borrower or is he like a renter? And Rava said a husband is not like a borrower, nor is he like a renter. Rather, he is considered to be like a buyer of his wife's property, as can be inferred from the statement of Rabbi Yossi, the son of Rabbi Hanina. As Rabbi Yossi, the son of Rabbi Hanina, said, in Usha, the sages instituted, in the case of a woman who sold her usufruct property during her husband's lifetime and then died, the husband can appropriate the money from the buyers, provided that he compensates them for their loss of the purchase. So evidently, the wife's property is considered to be owned by the husband. Now, Rami Bar Chama raises a dilemma. When a husband acquires the rights to his wife's usufruct property, that includes consecrated property. Acquiring property from the temple in this way is considered misuse of consecrated property. So in such a case, who is liable for me'ila, right, for the misuse of consecrated property? So Rava said, who could be considered to have misused consecrated property? Should the husband be considered to have misused the consecrated property? Certainly not, as while it is satisfactory for him to acquire non-sacred items of his wife's property, which are permitted for him to use, it is not satisfactory for him to acquire consecrated property. He didn't want to do that, which he knows is prohibited for him to use. Since he does not wish to acquire these items, he cannot be held liable for removing them from the possession of the temple. Should she be considered to have misused consecrated property? Certainly not, as also with regard to non-sacred items which are permitted for use, it is not satisfactory to her that her husband acquire them. Nevertheless, by virtue of the rabbinic ordinance, he does. So evidently, her husband's acquisition is not affected by her wishes, and therefore she cannot be held liable for it. Should the court be considered to have misused consecrated property as it is their ordinance that granted the husband ownership? No, because when the sages instituted the ordinance and they said that a husband is considered to be like a buyer of his wife's property, that was only with regard to non-sacred items, which are permitted for him to use. But with regard to consecrated property, which is prohibited for him to use, the sages did not institute an ordinance. So rather, Rava said the husband is liable for having misused consecrated property only when he actually takes and spends the money for himself, just as it is in the case of one who mistakenly spends consecrated coins for a non-sacred purpose. New subject. A dilemma was raised before the sages. If the flesh of a borrowed animal was weakened due to the labor it performed for the borrower, what is the law? Is the borrower liable to compensate the owner of the animal? Now, if we're paying attention, we immediately pause and say, what? Didn't we say that the borrower is always liable, whether the mishap that happened to the animal that he borrowed happened because it was lost, or because the animal was stolen, or because the animal died, or because the animal was injured due to circumstances beyond his control? In all these cases, the borrower is liable to pay the owner for the animal that was injured or died or was lost or was stolen while it was in his care, in his possession, his custody. So now we're saying, well, if he borrowed the animal and he was using the animal, and as a result of using the animal in the normal way that, he asked to borrow it, he said, I'm going to use it to plow my field, and he didn't do anything negligent. He was just plowing with the animal the way that the animal was intended to be used for the purpose of this borrowing. And the animal died in the ordinary course of its use for which he borrowed it. Is he liable? You'd be like, well, if he's liable in all those other cases where it's beyond his control, why wouldn't he be liable when the animal is being used within his control, right? And the answer is no, he's not liable. Why? One of the sages, and Rav Hilkiah, the son of Rav Avia is his name, said to the sage who raised the dilemma, by inference from your question, it seems that when a borrowed animal died due to ordinary labor that is performed, the borrower is liable. Why should that be? Let the borrower say, it was understood by you that I did not borrow the animal just to stow it under a canopy. I borrowed it in order to use it. And therefore, if it died while I was using it in an appropriate manner, I should not be liable. Rather, Rava said, it is not necessary to say that if its flesh was weakened due to ordinary labor, the borrower is exempt from liability. Meaning, it's not necessary to say it because that's exactly correct. He's not liable. So rather, even if the animal died due to ordinary labor, he is also exempt, as the borrower can say to the owner, it is self-understood that I did not borrow it just to stow it under the canopy. I borrowed it in order to plow with it. I plowed with it, and it died, like its time came. Even if the work that proximately caused the death, like it was out there plowing when it dropped dead, so you could say it's related to the fact that it was working, but it was working in a totally normal way, that's actually not going to trigger liability for a borrower who has the highest degree of liability. It's a very surprising law. But that is the law, right? Weakening and death due to labor. If one borrowed vessels, this is how the Shulchan Aruch puts it, if one borrowed vessels or an animal, and the vessels were damaged or the animal was injured while he was using them in the normal manner, he is exempt from liability, even if the vessels broke or the animal died. If he used them for an unusual task or in an irregular manner, then he is liable, as he would be liable for everything else that we've already said, loss, theft, or an accident beyond his control, or a death due to something beyond his control. So it's very surprising that here where he's using it in the ordinary way and the animal just expires, he is not liable. And the Gemara relates a certain man borrowed an axe from another man, and it broke. So the borrower came before Rava for judgment, who said to him, "Go, bring witnesses that you did not deviate from its regular use, and you will be exempt from liability, as this is comparable to a case of a borrowed animal that died due to ordinary labor." I'm almost done. Questions or comments, please get them in now. So the Gemara asks, well, and if there are no witnesses, then what is the law? And the Gemara provides a precedent. So come in here, a similar case. There was an incident in which a certain man borrowed an axe from another and it broke. And the borrower came before Rav for judgment, who said to him, "Go and pay him the entire value of a proper axe." And Rav Kahana and Rav Asi said to Rav, "Is this the law? Is it not sufficient for him to pay the difference between the broken axe's previous and current value?" And Rav was silent. He did not answer. And the Gemara concludes, and the law is in accordance with the opinion of Rav Kahana and Rav Asi, that the borrower returns to the owner the broken tool, and he makes up the remainder of the tool's previous value with a monetary payment. And just one, let me just read the way Rav Steinsaltz puts it, that if the animal died due to ordinary labor, he is exempt. This law is puzzling. If the animal died by an entirely unavoidable accident, completely beyond the borrower's control, he is liable. How then can he be exempt from liability if it died as a result of his own use of the animal? One answer is that the borrower is not responsible for mishaps that occurred due to the owner's negligence. And if the animal died due to ordinary labor, it can be assumed that it had a prior blemish or illness which the owner should have treated. And since he did not, the mishap could be ascribed as his fault. Very interesting. Very interesting. Am I seeing no questions? Maybe there's no questions. Looks like it's no questions. Okay. So that's what I've got for us today. And with God's help, we will be together again tomorrow, Thursday, at the regular time, 6 p.m. Pacific. And tomorrow we actually bump into two quite short pages. So we'll do a double daf and help us, get caught up since we're running a few pages behind. All the best.